Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. We are live and on the record.
Thank you very much. Good morning, everyone. We are here for our fifth case of the day. My name is Mary Thomas Sullivan, and the panel today will consist of me, Justice Sachs, and Justice Shin. We have one case before us to be heard in this virtual platform. Case number 20P0755, Commonwealth versus Ronnie M. Harris. Attorney Landsman, you may proceed.
Thank you. Good morning. And may it please the court, Ina Landsman for Ronnie Harris. Your Honors, I believe the vacatur is required because there were three sets of fundamental constitutional errors that lowered or shifted the burden on the only element at issue in this case, which is malice. And he was therefore convicted on less proof than required beyond a reasonable doubt, because the jury did not have to consider malice. Now, before I go into the specific arguments, I just want to very briefly go through the evidence from the defendant's perspective, because it was certainly warranted a manslaughter finding by heat of passion, by either provocation or mutual combat or imperfect self-defense. So there was evidence that previously Mr. Harris had been violently attacked by several men, including the decedent and Mr. Haynes.
Counsel, if I may, we, I think, are fairly familiar with the facts. So unless you think there's a particular fact that we might have overlooked or won't see when we reread the briefs, I suggest that you get right to your argument, because you have many arguments to make. And I think the panel, or at least speaking for myself, I have many questions. So is there any particular fact that you don't think we might have focused on that we should?
Well, thank you for that. So the only thing I would point out is that this case is different than others in that there were multiple witnesses who supported Mr. Harris's point of view that he was attacked multiple times. And then I can just move on to the first argument.
So for your first argument, which is the Sandstrom error, you've pointed to a federal standard under Hill and Libby that we grant relief unless there's no reasonable likelihood that the jury interpreted the language as creating a mandatory presumption. Is there a comparable state standard that also applies to a claim of mandatory presumption error?
The cases, my reading is the Massachusetts cases that have dealt with this issue have used the same standard. There's some disagreement about how the harmless error prong is interpreted. But certainly cases like Raposa followed Hill and Libby and Francis. Okay,
so it's not like the moral certainty argument where there's seemingly a different and slightly more defendant-friendly state standard. Your view is that the state and federal standards are the same.
It is, Your Honor.
Okay, thank you.
As you know, it's a three-step analysis, and the first step is there a mandatory presumption? And in this case, there certainly was that the jury was instructed that malice is implied to every cruel act, which is very similar language to what was found to be a mandatory presumption in numerous cases like Hill and Libby. And it was reinforced by other language that would have told the jury that there was this expansive idea that malice is present whenever there's cruelty, which at the time was understood to be just a painful act. So it was reinforced, for example, by quote, malice as used in the technical sense, not only includes hatred and ill will, but every unjustifiable motive. And then there was some language that was pointed out by the Commonwealth, which I think also supports Mr. Harris's position, where there were two instances where malice was defined as something without legal justification. Now, manslaughter by heat of passion is not legally justified. So I think based on that, the jury would have understood that unless he was entitled to use self-defense, they did not have to consider heat of passion defenses, and that was on pages 48 and 49 of the 7th volume. Now, the second step obviously looks at the instruction as a whole, and the case law is really clear that it's not enough that just some parts of the instruction are correct and others are not, because we can't just assume that the jury followed, some parts and not others. So the law is pretty clear that the instruction not only has to state the standard correctly, but it has to be explicit why the incorrect language is incorrect. And that's in cases like Hill, Sandstrom, Raposa, Francis, and Libby. And in this case, there was a lot of fire and brimstone language that really, that would have taken malice out of the jury's consideration. And there was no explicit correction of the incorrect language. There was no indication that any parts were more correct than others. There was no statement that the inference of malice was permissive rather than mandatory. So I won't go through all the fire and brimstone language from Medeiros, but the bottom line is the judge instructed them that they had to consider the Commonwealth's right to a conviction to be equal to the defendant's presumption of innocence. And similarly, they said things like, there's no wrong to the victim greater than depriving him of his life. And that's really not relevant under the law. They talked about the importance of punishing those who break the law, otherwise life will become cheap. So there was a lot of really emotional, clear language that counteracted the long, technical, and rambling correct language. And in terms of the
Counsel, may I ask you though, and I'm anticipating what I think we'll hear from ADA Shorey, which is, was this not considered on the direct appeal? If we were viewing this for the first time, I think at least my questions to you would be quite different, and my consideration of the case would be quite different than the fact that this was already reviewed once by a court that we're not allowed to overrule. So how do we place your argument regarding the fire and brimstone language and the malice instruction in that procedural context?
Thank you for asking that. So Sandstrom postdated Mr. Harris's plenary review. So it was not available at the time of his plenary review. And I believe it's Rembazewski is clear that if an issue was not available at the time, then there cannot be any estoppel or preclusion. So I would argue that, and actually I believe Rembazewski says that when these issues are not available at the time of plenary review, it's treated on collateral review as if it's there for the first time in the proper course.
But the cases involving the malice instruction had been decided at the time of plenary review, had they not?
So Mulaney predated a plenary review. So it had been decided only in terms of self-defense. So in footnote 4, and Harris makes clear that the court did not even consider manslaughter by heat of passion at all, because trial counsel had not argued the case at that point.
So where the SJC said we're not going to consider any claims of error in the reasonable provocation or heat of passion instructions because the case wasn't tried on that theory, what has changed that should make us take a different view?
Well, so first of all, I think what's in footnote 4 is dicta. The law is clear that if the evidence supports a theory, then the jury needs to be instructed on it.
But they didn't say the evidence was or wasn't sufficient. They just said, we're not going to consider it whether these instructions were good or bad because the case simply wasn't tried on that theory. If they think that that is a ground not to deal with any claimed defects in the instructions, then why should we say, okay, now we're going to look at the claim defects?
Because the law is that he was entitled to instructions on theories that were raised by the evidence. If you look at, I think it's volume 7, page 11,
But that was true at the time of the SJC's review as well. Yet they said, no, we're not going to look at this because this wasn't the theory on which the case was tried. So I guess why shouldn't we say the same thing?
Right, because plenary review, for example, does not consider things like ineffectiveness. And in this case, I think based on subsequent case law, such as Acevedo, there's a strong argument that counsel was ineffective for not raising manslaughter by provocation.
Acevedo, but your ineffective assistance argument aside, and I understand why that would not be foreclosed by what the SJC did. Is there any other reason that we shouldn't view that language in footnote 4 as saying, there is no more reason for us to look at instructions on a theory that wasn't pursued than there was for the SJC to do it?
Well, so first of all, what's in footnote 4 is dicta. So I don't believe that it forecloses you from looking at these issues, especially where you're dealing with issues of constitutional magnitude. So in terms of harmless error, in terms of Sandstrom, correct instructions may very well have made a difference. If you look at the options open to the jury, it was quite clear that they were willing to give him the benefit of the doubt. So these instructions had taken malice out of the jury's consideration, and they could have convicted him on murder 1, but they didn't. So it's clear that there were aspects of the evidence that the Commonwealth put on that they did not believe.
You're gonna have to help me with the prejudice issue. So in what scenario could the jury have rejected self-defense but found provocation?
So you don't need to show self-defense to show provocation. So, for example,
the jury here rejected self-defense.
Mm-hmm.
In light of the evidence presented by both the Commonwealth and the defendant, why isn't it almost certain that the jury simply disbelieved the defendant's story by rejecting his claim of self-defense? It's hard for me to see, given even viewing the evidence in the light most favorable to him, taking his testimony, how the jury could have rejected self-defense under the facts that he described and still found provocation.
So I have a several-pronged answer to that. The first is because of the issues with malice, they may have thought that he was entitled to use self-defense, but that he used excessive self-defense.
But his testimony was they had him pinned to the ground and were lunging at his head with knives, right? So, so you in your brief, you posit that maybe they found that he didn't make any attempts to flee, but he's saying he's pinned to the ground, and you posit that maybe they found that the amount of force used was excessive. But if they believed him that they're trying to stab him in the head, it's really hard for me to see how they could have accepted his testimony, rejected self-defense, and still found provocation.
Or they may have, in terms of the decedent, there was testimony that the decedent was 8 feet away, and then there was testimony that the decedent was right on top of Mr. Harris. And so they may have thought that he might have had a chance to get away, but at the same time, because he was jumped by these people, threatened by people with knives, that maybe that was sufficient for provocation or heat of passion.
But wasn't his own testimony that he was knocked to the ground, and while he's on the ground, one of them, I don't know if it's the decedent or the other man, was lunging at him and plunged the knife toward his head. And it was at that moment that he shot near him. Mm-hmm. Right. So, I mean, how in that scenario could they have rejected self-defense, but still found provocation? I'm having a lot of trouble with that.
Well, so it may be that they believe there was imperfect self-defense. In other words, that he used excessive force, or that
But
So,
we have to assess prejudice based on how the case was tried. And why isn't it almost far more probable, if not certain, that the jury just simply disbelieved him? Because if you take the Commonwealth's version of the events, plainly that does not give rise to any sort of defense of self-defense or provocation, right? So you have two very disparate versions of what happened. It's not like the case that you relied on, Spear, where there are just disputes about maybe who instigated. But here, I mean, you have very different stories, right?
I think so, but I don't think that we can assume that the jury totally disbelieved him on self-defense, because had they been properly charged on malice, they might have convicted him for manslaughter based on the imperfect self-defense.
Right, but in that scenario, they would have had to find provocation, right? Because there's no dispute that the shooting was intentional. And so it could still be without malice if it was done in self-defense, which the jury rejected, or if there are other circumstances that would justify the shooting, which I take your argument to be was provocation.
I'm sorry, I didn't understand your question.
So there's no dispute that the shooting was intentional. And you argue, well, that doesn't, it could still be done without malice, even if it was intentional. And that would be true if he acted in self-defense, which we know the jury rejected, or there are some other circumstances that justify the shooting. And I take it your argument is that those circumstances are provocation, right? So in order to find harmless error, we would have to determine that on the evidence presented, the jury could have rejected self-defense, but still found provocation.
That's correct.
Okay.
May I ask a question about the moral certainty language? Can that language be explained as the judge tried to do here, as that degree of certainty which you jurors would like to have when acting on important affairs in your own personal lives? Now, I've read the cases that say giving particular examples of those important decisions can be problematic, but the cases seem to suggest that the statement without the examples may be permissible. Does that statement give sufficient content to moral certainty and emphasize the degree of certainty that's required so as to make it permissible? And I guess specifically I'd ask you, are there cases bearing on that?
Right. So for example, I believe it was the Garcia case that said that if you talk instructions like what you're talking about that don't talk about specific examples are okay because the rest of the case focuses the jury on what's happening in the courtroom. In this case, there was a lot of that fire and brimstone language that focused the jury on what was happening outside the courtroom. So I think the language you're talking about would have added to the prejudice from the moral certainty problems, or erroneous or improperly contextualized language, I should say. Okay, thank you.
Any further questions from the panel? Seeing none, Attorney Shorey, and once you begin, your clock will also appear in the upper left.
Good afternoon, Your Honors, and may it please the court, Benjamin Shorey on behalf of the Commonwealth, asking you to affirm the denial of the defendant's motion for a new trial. I do think it's important, and of course, flawed jury instructions, deeply flawed jury instructions would be improper despite the passage of time. But I do think it's critical to contextualize these instructions in a particular time when we go and assess them. And it's especially important when we look at this first issue, because it is not as though the normal course was for judges to give the instructions that we're used to today and then tack on this language. The instructions were pretty free form, frankly. And you can see that especially when you look at the two cases, Hill and Libby, that the defendant relies on pretty heavily. The instructions in that case, or in both of those cases, involve the judge really not defining malice at all. And you can look at the full relevant instructions in both of those opinions.
Yes. You say here that the judge gave I think you call it a correct and precise definition of malice. I didn't see what that was.
Well, so and so that's in our case, I think it is different from Libby and Hill. In that on page 1021, the judge defines malice, and of course, when I say correct and precise, I don't mean it's as lengthy as what our model instruction would be today, but you see a clear and I mean, essentially he defines third prong malice as we define it today, and that is completely and utterly lacking in both Libby and Hill. The instruction that
but he kind of misdefines it, doesn't he? He says clear and probably do grievous bodily harm and plain and strong likelihood of death. That's prongs 2 and 3, isn't it?
Yes. Well, and it's combining them. So I think he's giving the defendant really a benefit he wouldn't be entitled to.
Yeah.
Right.
But the question I have is, what part of the instruction here not only contradicted the malice is implied from every cruel act instruction, but explained it and harmonized it with some proper definition of malice, which is what Raposa and other cases say is required.
Right, and I think that's where you have to go to that page 1021, the language we were just talking about, where there was an actual definition of malice. And I understand that the actual challenged language here, the reference to cruelty, doesn't come to the next page, and it to some extent it stands in isolation. But I do think that has to be the key distinction, is that there is that language given, there is that definition given, and there, Medina clarifies that point that you just raised, where the language can't just be contradictory. And I think what they're talking about there is generally about the Commonwealth's burden of proof, and generally about that burden of proof being imposed on every element of the charged crimes. I don't think it's saying we need, even a proper definition of malice won't rebut this cruelty language, because
I'm having a hard time seeing that language at 1021 as even a definition of malice, as opposed to merely an example or a couple of examples of what could be malice.
I'm glad to look at it here, but I think it's my recollection is the judge is expressly trying to define malice. If you give me just one moment here. I mean, if we look at the beginning of this paragraph, a killing may be malicious, and understanding that he's just defined essentially first prong malice, right, with the intent to kill, when he's defined first degree murder, and then goes on to a killing may be malicious and consequently murder, even though the slayer didn't wish to cause it. And so that's the introduction to the paragraph, and then it goes on to define it, essentially properly, right? And I understand your point, certainly, that it isn't what we would expect today. But when you look at these other cases that address this, Hill, it's a supplemental instruction where the jury is specifically asking, can you tell us the difference between second degree murder and manslaughter? Yeah. And the judge's instruction makes some vague reference to his prior instructions and says, don't quote me on this, and proceeds, never comes close to defining malice, and then says, so it can be it uses words like, from a bad heart and stuff like that, and then says it can be inferred from cruelty. The only clear definition the judge gave there of malice was, the improper presumption. And I think that's just a vast distinction from what we have here, though certainly Justice Sachs recognizing that this would not be a model instruction if it were given today. That I think we can all agree on.
Yeah. Can I just go back to a point that I asked defense counsel? In fact, your brief at page 34 identifies different state and federal standards for evaluating the moral certainty instruction. and the federal standard is a reasonable likelihood that the juror understood the instructions in an unconstitutional manner. And the state standard is we look for possible misunderstandings by reasonable jurors, which is more defendant friendly. Is there a comparable difference between the state and federal standards on the first issue, the mandatory presumption issue, or do you agree with defense counsel that the state and federal standards have basically been treated as the same?
I agree with defense counsel on that. I'd point to both Medina and Raposa. I think they both just state the one standard.
Thanks.
If I can get on issue one, my last point on that, if the court doesn't have other questions, is just getting to this harmlessness issue, and just clarifying that this issue simply wasn't the issue before the court. And when we look at, I think this is an important distinction. We're talking about affirmative defense of self-defense. The issue of affirmative defense has really only come into play if the elements have been satisfied.
Well, but the court has said that self-defense negates malice. Most recently, they said that in Commonwealth versus Fernandez, a 2019 case, 483 Mass 1 at 15 note 13. So where self-defense negates malice, I don't understand how the error could be harmless.
Well, I'd have to look at that specific case, Your Honor.
Yeah, but it cites the Connolly case,
sure. And so I understand that's the language that's been used, but I believe it's Grafton that I cite in my brief on the point that and I think if we just take those as kind of contradictory language, there's no question that the way I stated my brief, I think has to be right, that malice is established before we get to self-defense, that the intentional act of firing the weapon here clearly came with the understanding that there would probably be death or serious bodily injury here. And in the specific, even if that isn't universally the case, it certainly is here where the defendant acknowledged that he intended to strike.
But Grafton was a case about affirmative defenses generally.
That's right.
How can we take Grafton as controlling over the more recent decision in Fernandez, which is about self-defense specifically? Because
I think if you take, let's just go back to the broader harmlessness error here and say, take the technicalities of whether, what an affirmative defense is accomplishing. The self-defense instruction the defendant received stood as a full basis for him to be acquitted if the jury bought it, regardless of this instruction on malice, because it did refer to the essentially third-pronged malice. So at the end of the day, I don't think anyone could.
They might never have gotten there if they took seriously the statement that malice is presumed from every cruel act, and they said, "Gee, he just shot him when he didn't need to." I mean, maybe they thought it was excessive force in self-defense, but once they were told that a cruel act means malice, they could take excessive force in self-defense as malicious and convict him of second-degree murder, couldn't they?
Well, they would have had to disregard a whole lot of that instruction on excessive use of force. It would have been, it's hard, that part is hard to imagine them taking that one line and using it to vacate this entire.
You agree that the two instructions are in conflict then?
No, I think I'm arguing that point just in the alternative, accepting if you're accepting that self-defense does negate malice. I do think it's not especially helpful to get caught up in the technicalities of it, because of course that's what the jury is not instructed on all. Just need to focus on what they're instructed and how they would have understood all that. The issue in this case of that the defendant was claiming, was acknowledging he intentionally fired this weapon at both victims, simply was not in dispute. And And I have a hard time imagining that line in isolation negating that entire theory of the case, especially in light of the malice instruction that was given and the exhaustive self-defense instruction. I will point out that we'll get to in a moment, there may be some dispute on what the SJC specifically found on other points, but they did address the self-defense instruction. So I think that point stands, and they did it specifically. They specifically applied Mulaney in that to that instruction.
Before we get to Mulaney, though, I just want to make sure we've gone straight to the merits here, and I want to make sure I understand what you think our standard of review is here. Do you agree that because Sandstrom came out after this case was decided in the SJC, that we are to look at the moral certainty and instruction and the malice instruction anew?
I do agree. Yes, I think on both points 1 and 2 from the defendant is entitled to an evaluation on the merits.
And if that's the case, does what defense counsel referred to as the fire and brimstone language come in again through the back door? I recognize that language was evaluated before, but it was evaluated in the context of a different understanding concerning the malice instruction, if not the moral certainty instruction. And do we then take into consideration, if we are looking at this anew, do we take into consideration the prejudicial effect of the other remarks that would now be not approved?
Well, I think they're very, at most, very secondary points. I mean, you kind of have to look at each one and see the extent to which it was established at the time the SJC reviewed the case. But even today, the language, I mean, again, stepping back big picture, there was clearly an intent or an understanding that judges had to impress on the jury the importance of their decision, both importance to the defendant and not convicting innocent people, and the importance to society to get guilty verdicts correct. And that language clearly is not used to the same extent now. But it's also doesn't serve as a basis for relief. And I'm not sure that it's a even erroneous instruction. I would,
if we're trying to sort out whether the jury got malice right or whether they understood excessive use of force in self-defense as a road to manslaughter, and we're aware of some of this language of the importance of punishing crime, that doesn't play in our assessment of prejudice?
Again, I haven't seen any case from defense where it's anything more. It's certainly not a basis for relief. And
I'm not saying it is.
Sure.
I'm saying, do we consider it on prejudice if, and that's a big if, we were to find another basis for relief?
Right. I think it can. The instructions have to be considered in their entirety, and so certainly other things that are frowned upon or or erroneous in the instruction can be considered. But you consistently see in all of the cases that's a very secondary consideration, especially I think what you're talking about now, again, certainly not part of the model instruction now, but I also don't think it's erroneous. And it can't, maybe we need, I don't know how far to get into that with hoping to be able to address a couple other issues very briefly here. But I don't think that the language was especially problematic here. And actually the prosecutor, I think, repeatedly noted the importance to both sides of getting the decision correct, as did the judge. The problem with the fire and brimstone language is not that it impresses on the jury the importance of this instruction. It's that in some cases it was very one-sided. Here it was not one-sided. The judge did stress both the importance to society of a correct verdict and, of course, the high importance to the defendant.
Before you go on any further, are there any other questions from the panel?
I have one, similar to what I asked defense counsel. are there cases bearing on whether the moral certainty standard can be explained by a reference to the degree of certainty you jurors would like to have on important decisions in your personal lives? Understanding that kind of instruction can be problematic if coupled with examples, but that standing alone, it seems to give some content to the beyond a reasonable doubt standard. So are there cases that we
Yes.
should look at on that particular issue?
Yes, I would point you to Commonwealth versus McGrath, 437 Mass 46. And I could give you one other here very, very quickly. But while I'm finding that, I would also note that the criticism of that language was already established before the defendant got his direct appeal in this case. So that was available for the court to consider. I believe the other case would be Commonwealth versus Ferreira. Give me one. I apologize. Commonwealth versus Ferreira, 373 Mass 116.
Okay, thank you.
And so if I
we've already gone considerably over, and in fairness to defense counsel, we'll try to keep some moderately equal amount of time. Are there any other questions from the panel? Seeing none, I think we could have given a half an hour to each side on this argument. It's been very well briefed and very well argued. And thank you both very much. And we thank our clerk's office and our IT professionals and our court officers and law clerks and interns for everything they've done to make this sitting possible today. And that concludes our session. Thank you.